Good evening, and welcome to another installment of the Science for Today series put on by the Faculty of Science and Technology, UWI. Very interesting topic discussion today, and we've assembled a very able panel to discuss the substantive issue we want to highlight today. First, we're going to have retired Lieutenant Colonel Godphey Sterling, who is the head of Jamaica Cyber Incident Response Team, and also Ministry of Science, Energy and Technology. Can we have Mr. Jason Scott, Head of Digital Transformation at GK General Insurance Limited, also Deputy President of Jamaica Computer Society. We have Dr. Curtis Busby-Earle, Senior Lecturer in the Department of Computing at UWI. He's also leader of the Computer Intrusion, Forensics and Exploitations Research Group. We have Mr. Andre Sheckleford, lecturer in the field of law and attorney at Hart, Muirhead, and Fatta. And I am Professor Daniel Coore, Professor of Computer Science in the Department of Computing at UWI, and I'll be your moderator for today. Earlier this year, on February 17th, journalist Zach Whitaker published a story with TechCrunch magazine, revealing that data that had been collected by the JamCovid app had been exposed to general access to the internet for an unknown period of time. The data included, among other things, the private data, such as names, passport numbers, and COVID test results of hundreds of thousands of travelers to Jamaica during 2020. The incident and the Jamaican government's response have sparked many discussions in Jamaica, not least among cybersecurity practitioners, about the circumstances surrounding the incident and recovery. Apart from the obvious question of whether and how the Jamaican government's procurement process for software provides security assurance, one interesting question that has arisen is whether the whistleblower of a discovered breach is liable to be prosecuted under the Cybercrimes Act. In an article posted on February 25th this year, 2021, Nationwide Newsnet reported that National Security Council says the findings thus far indicate that while there's evidence of unauthorized access to the JamCovid app, there's no evidence of data exfiltration. The article further reported that Jamaican law requires that all instances of unauthorized access be investigated. So it would appear that accessing online data that has not been secured at all could still be deemed to be unauthorized under the Jamaican Cybercrimes Act. And a person who reports such a discovery would necessarily become subject to investigation. Think about that for a moment. The prospect of this metaphorical shooting of the messenger is alarming for professionals in the IT security business, because the sources of vulnerability in a service that is deployed online can sometimes be subtle and are often unknown at the time of deployment, even with the most rigorous development and deployment processes in place. It is therefore often a welcome intervention to online service providers when ethical hackers and other benevolent dwellers report discovered security vulnerabilities privately so that they can be closed before those vulnerabilities are exploited by bad actors. The Jamaican Cybercrimes Act, on its surface, appears to criminalize benevolent action. Is this actually the case? To what extent can IT security professionals still exercise best practice when interacting with systems under Jamaican jurisdiction? Does the fact that we have to ask this question already compromise the security assurance of any system under Jamaican jurisdiction? Here to discuss this issue, these questions, and perhaps others are our esteemed panel this afternoon. We'll begin with Lieutenant Colonel Godphey Sterling. Welcome, sir.
Good afternoon, David, Daniel, and thank you for having me. I hope we have a very good discussion this evening. And certainly, while I seem to be the only public servant in the room, I am by no means a lawyer, and so my understanding of the law will really be third hand.
Absolutely understood. And that's why we have some lawyers on the panel. But we have a lawyer on the panel and we have other lawyers on there as well. So since is it pronounced JACERT or JACERT? How do you pronounce the acronym for your entity?
Currently, we pronounce it JACERT, but JACERT works just as well.
Okay. So, I mean, can you tell us a little bit, just for everybody's benefit, what JACERT does, what its purpose is, and then we can get into how this plays out with the Jamaica Cybercrimes Act.
So, consequent on the promulgation of the 2015 National Cybersecurity Strategy, the National Cyber Incident Response Team was stood up as a major pillar of actually operationalizing the strategic goals of that strategy. Out of it came the Cyber Incident Response Team, and the Jamaica was sort of added when it was envisioned to be operating at the national level in response to cyber incidents and any cyber-related criminality that had a national impact. Currently, we have 12 mandates. They're listed on our website. But essentially what we do from day to day is to manage cyber incident response for the government of Jamaica, as well as those which have a national implication. Essentially though, over the 5 years of our existence, we have found ourselves responding to just about anyone who reports a cyber incident, because we are it as far as the government of Jamaica and moving in cyberspace as far as incident response is concerned. We're heavily supported by the Communications Forensics and Cybercrimes Division of the JCF, as well as the major organized crime and anti-corruption agency. Now, what we have is a situation where, whilst we are stood up, we have no legal basis to mandate certain basic requirements as far as incident response in terms of the sequestering of artifacts, the forensic analysis of the incident, and how the reports are actually generated. So essentially, we really depend a lot on moral suasion or active participation and the leveraging of partnerships in order to get a fair bit of our work done. So in a nutshell, that is what we do. We're really meant to be responding to national level events, but because of the fledgling nature of the cybersecurity within government, we respond to anything that comes.
Right, okay, thank you very much. That's a comprehensive summary of what you're about. A couple of things that occurred to me even as you spoke. Those incidents that are being reported, what is the trigger for when somebody comes to you and says, I have an incident? Is it something as blatant as, well, our files are missing? Or is it something that might be potentially a problem? Somebody discovered a port open or something that shouldn't have happened, and they suspect that maybe some personal information might have been leaked? Or is it as subtle as that? Or do you actually usually get far more direct and obvious breaches reports?
Daniel, the reports run the gamut, and the only way we're able to survive is really through our processes of triaging, which allows us, once the report comes to us, to look to see how do we really classify this. And we've used international best practices, and so we have 3 bins essentially that we put each reported incident in. So there's the event, which really is just probably a concern reported by someone, which we can essentially deal with by providing advice on to remediate or where to go to get the actual remediation. Then there are incidents, and we look at the impact, the severity, and we try to work with the affected parties to bring about resolution and remediation. Then there are what we assess to be criminally liable actions. and these are referred to the Jamaica Constabulary Force's Cybercrimes Unit, or to the major organized crime and anti-corruption agency. Now, what we find though is that oftentimes when the process starts, so they will come with the event and we will provide the guidance that we can, they abort in the middle of it. And so there is usually sometimes a challenge with pursuing.
I beg your pardon, who aborts? Who aborts? The person giving you the report or the person trying to help you investigate it?
No, the victim. Because the majority of incidents that we see are actually incidents that affect the individual. A lot of the companies do not report to us, or they try to remediate in-house or contract corporate entities that provide this sort of service.
Is it JCERT's responsibility to determine what ought to be prosecuted, or does the process require you to report somewhere else who then makes that determination?
So through our process of triage, if we determine that the incident being reported to us has a criminal overtone to it based on the guidance of the Cybercrimes Act of 2015, then we refer it to the JCF. Now, they have the responsibility for investigating that incident further. And there is a cybercrimes unit in the Office of the Director of Public Prosecution that is meant to help them to marshal that evidence to the point where a prosecution can be brought if it is deemed to be worthy. If it's not deemed to be criminal, then we do the investigation and we would activate a team, respond to it, whether virtually or in person. And we would follow the set out steps for treating with data and artifact collection.
Sorry, maybe I'm missing something. So you said it sounded like if the determination whether it's criminal happened before the data was gathered. I'm sure that's not really what you said. What happens?
No, it's two separate points, not to be conflated. So one, I just ran down the list. The other, I was expanding on what would happen at each juncture.
Okay, so but there's a point at which you collect information from the report.
Yes.
The process that you, after your triage, you pass on to the Director of Public Prosecution, whatever you have, and it's up to them to determine whether there's criminal liability?
No, we do not interface directly with the Director of Public Prosecutions. We interface directly with either the JCF or MOPA.
Oh, I see. It is up to them to take it to the DPP.
Right.
But who makes the decision whether a breach may have occurred of the, for example, in this case, the Cybercrimes Act?
So based on the provisions of sections 4 and 5 of the Act, and section 14 to a lesser extent, which seeks to support those two sections, if the event that we're looking at falls within the classic definitions that are there, then it is referred with the artifacts and evidence collected to that point to either the Cybercrimes and Forensics Division or to MOPA itself.
Okay. Now let's bring this closer to the topic that sparked this panel in the first place. An incident like what was discovered earlier. Someone comes to, let's say they're going to report it to JCERT to say, hey, I just noticed that all this information Jamaica government is collecting is available publicly. At that point, let me ask first, could that be reported anonymously, or is that not possible?
It is possible to report it anonymously. Currently, our reporting mechanism actually mandates or have required fields in web version for an email address and a name. And usually that is for follow. The fact it can also be a deterrent for those who wish to report incidents. But for those persons who visit or call us, if they desire to remain anonymous, we do. And in the collation and use of the data that we collect, we do anonymize the persons and the entities who report these incidents. So yes, it is possible, but not, it is not evident from
yes. Now, normally, the reason for permitting anonymous reporting is to help the witness separate themselves from perhaps fallout for making that report. And in a criminal investigation, that makes perfect sense. In the specific context that we are dealing with today, though, there is, in this case, in fact, often a best practice that recognizes and encourages the reporting of these things. So usually it's actually not, in a different scenario, there wouldn't be any incentive for someone to anonymize that report. They would actually proudly say, hey, I found a vulnerability in your system, and sort of be happy to be the one to have brought it to your attention, and being labeled a good actor, ethical hacker, etc. In the collection of this information, given what the Cybercrimes Act says about unauthorized access, is that a consideration when you are processing, that you need to now list whoever brings that report to you as someone that needs to be investigated? Or is that not for you at JSOC to determine?
So the short answer would be it is not for us to determine. The long answer would be that, as you in your preamble, the Cybercrimes Act really, on the face of it, criminalizes unauthorized access. And so if you happen to be on the net, say, for example, you're a budding security researcher, and you end up entering an internet-facing resource because it was not secure. Mm-hmm. The matter of whether or not you gain unauthorized access then becomes a final point of law, because what Section 4A says is that you're entering the system without authority with the intent to do something nefarious or malicious. And so by the fact that you can prove that your actions were not ill-intended, you ought not to have an issue. Now, where JSERT is concerned, we are scientists first and foremost. And so our basic response would be, what is it that you discovered? And can we see how this happened? And based on the indicators of compromise, whether or not what you've said you did is actually what occurred. And so from there, our recommendation would be, if it warranted being reported to the JCF, that we reported it with an anonymous side to it. If it did not, then we would work with the person who reported it and the entity affected to effect the remediation process.
Okay. I actually appreciate the answers you're giving. They do lend some clarity, and I'm sure the audience is going to have a few more for you eventually when we get there. I have one question regarding, and this is your subjective opinion now, before I move to another panelist. That is, in your opinion, do you believe that the incidence of reporting is seriously curtailed by the Cybercrimes Act as it is now? So one is, do you think it is an issue? And two, well, maybe you can't measure because maybe you don't know. I was going to say, though, I was going to ask whether it is in fact having an impact on who comes forward. Do you think it is deterring good actors from bringing a report to you?
It may be, and the fact is that there is such a high level of underreporting that it really is difficult to gauge. But certainly, when we think about people coming forward, when we think about persons who may have discovered vulnerabilities, we have to recognize that the maturity of our cyberspace ecosystem and the ability to respond and to prosecute cases is not such that we're at the stage where we can facilitate bug bounties, for example. And so because of the always imposing nature of the Cybercrimes Act, it is better to actually work with entities that are putting products online, work with entities that have internet-facing resources to say, look, I am a computer science student, I'm in my third year, I have this research to do. Can I do this to your system? And once you have that permission, then it negates the impact of the Cybercrimes Act totally. So if we can do that, or we can use pre-production versions of systems that are being placed online, working with authorization from the owners, then we negate that. It is a work in progress, Daniel, and certainly against the backdrop of the current review of the extant cybersecurity strategy, we are seeking to bring that conversation to the fore, where security research, vulnerability testing, I don't want to call it ethical hacking because I don't believe our ecosystem is mature enough for that. We're trying to take away a lot of the weight from the researcher and put it on the owners of the resources to work with these persons to ensure that we put our best products online.
Okay, wonderful. And I'm actually very, very pleased to hear what I'm hearing there is that A, the act is under review, and B, that the kind of direction it is likely to move in, that maybe you can't predict, but that you would push it towards would be, in fact, to make it far more clear what it means to actually be a bad actor, and to reduce the burden on those who might very well be trying to do a good thing by bringing attention to a vulnerability. It sounds to me that I could be trying in that direction. That
we have to go in that direction if we're going to mature at the rate we need.
Okay, great. Very encouraging to hear. Very, very encouraging. Let me very much, Lieutenant Colonel Sterling, very much indeed. Let me now move to Mr. Scott. Welcome.
Hi, Jason. Thanks for having me.
Welcome, Mr. Jason Scott. You have quite a bit of experience in the private sector space, and with, I guess, overseeing, managing many deployments, service deployments.
Yeah.
So, in your opinion, let me start by asking a sort of basic question about how is security assurance managed? If you are an entity that has an online presence that necessarily faces the public, has to have interaction from any and everybody online. Obviously, there's a certain security requirement. What's the general mechanism that one goes about if you are such a company, try and provide that security assurance?
So to start there, I mean, that's a very broad question.
Yes.
So let's break it down into smaller pieces. So we have an online, posture. We have a website. Let's assume that we have, online access to our platforms as well. The main thing that we do is during the development or contracting process, we adhere to secure application development best practices and principles. So we start there. So as a software engineer, we're doing code reviews. We're looking at doing stuff like ensuring that we're not vulnerable to SQL injections, that we don't have any buffer overflow attacks, basic stuff from a software development point of view. We also implement a rigorous CI/CD, that's a continuous integration and continuous delivery process that does some automated checks for us as well to ensure that the platform that we're building is secure to international standards, and then we deploy it. If it is that the application is now in production and somebody finds an issue with it and they reach out to us, we don't attack them. we definitely welcome them with open arms. We say thank you so much. What happened, and generally what happens is they let us know, like, these are the steps that we took. This is how we gained access. This is a copy of what happened. We want to work with you to fix it. And we put them in touch with our developers, or the developer in charge will just, take over and then, work hand in hand with that person. And then on the corporate side, there's usually, not usually, there's some way to say thank you for someone who disclosed discreetly that part of it. So that was me on the private sector side with experience in Jamaica and overseas.
Before you leave the point, because we haven't really defined what a bug bounty is, and it sort of is in the title. So perhaps you could illustrate, would that be an example of a bug bounty, that what you just described about the reward, or
Yeah, I would categorize it as a bug bounty, but a bug bounty is a more structured program. It's a standard way to communicate breaches, bugs, exploits, hacks on a platform in a trackable, measurable way. So if it's not something that is necessarily malicious as well. A lot of companies internationally, well, bigger tech companies internationally, like GitLab, Stack Overflow, Bitbucket, GitHub, they have bug bounties where these are known issues that people may find, and the bug bounties, how will you go about fixing them? So that's a more formal definition of a bug bounty. What happens in the space sometimes here in Jamaica, it's quieter because it's very discreet. It's handled in a very discreet fashion. But there are no formal bug bounty programs in the Caribbean that I'm aware of right now.
But the basic idea of a bug bounty, just for the sort of layperson watching this, is that it's some kind of incentivization for reporting a vulnerability in a way that doesn't cause harm, right?
Yeah, you can have it a Crime Stop. Like right now, you can call Crime Stop to report a crime. They handle it discreetly. If the report pans out and culminates in a criminal investigation, you receive a cash payout for your contribution. So it's like Crime Stop, but for IT professionals.
Right. Good. All right. You were about to move on to, I don't know if you were making a further point or if you're moving to a different scenario in answer to the same question.
So it's a continuation of the question. So that was my experience in Jamaica. I've had the experience as well as working overseas. The company I was employed to had branches in Canada, North America, and Jamaica. And there are certain, employees in the company who have, a certain level of security clearance with that particular country, where they are called upon, internally to help the particular government agency or particular governments to assist in triaging issues when they. So if, let's say, there was an incident on the CIFER website, for example, that's the Southeast Regional Health Authority. And it was reported to them. They would then reach out to that company, but that company has designated this particular person who has the appropriate security clearance to go and help them with their system. That's a model which I believe is more sustainable and more tenable for the climate such as Jamaica.
Well, I think I've heard of that model as well. In for example, when you hire a consultant. Often the consultant hire an ethical hacker to attempt penetration testing and so on, and sounds very similar. But I think in that context, though, that wouldn't be a violation of our Cybercrimes Act. That would have been an explicitly permitted action. And so I don't think that is a challenge in terms of what Cybercrimes Act is setting out. What I am trying to get at is that it would appear that the Cybercrimes Act, as it stands, sets up things so that it potentially criminalizes good actors. And what I'm hearing from you is, in fact, that action of being able to report a vulnerability discovered is something that you rely upon as a service provider. It is part and parcel of what you expect when you deploy a service. Right. Okay. And just for the sake of those who don't necessarily understand how software systems are deployed, do you think that when a vulnerability exists, that's a sign of negligence? Is that just bad practice by the computing, the software developers or the deployment IT specialists?
I would never say that. I would never say it's negligence, because you can always get up and go outside, and just forget that your zipper is down. So it's not necessarily an act of negligence. It's more of you forgot something, or you was just overlooked. Because there are tons of cases all across the world, globally, like literally, where people leave the production, the development password as password, and then promote that to production without ensuring that the right things are done properly. You have people who just forgot to put on a password altogether, because it's very rapid. It's a quick development. You need it out there quickly. And then there are cases where it's just misconfiguration. instead of turning off debug mode that would expose things that a developer would need to fix the problem.
Right.
You left it public.
Some of those examples you just gave, I think some lawyers would say, "Boy, that's negligence," But we'll let them opine on that, and that's perhaps something that the courts would litigate. But what I wanted to try and press on as perhaps a developer, given what you've said, you might have done some work in that space. Right. Aren't there instances where the kinds of vulnerabilities that could arise have very little to do with any kind of incompetence or negligence, even to say forgot to do something? Aren't there situations where maybe the system using happens to have a vulnerability that maybe you're not responsible for? You just happen to be using the system that has that.
So there are cases where I think that's called a 0-day, where those level of vulnerabilities, it's not your fault. It's just something inherent in the system. And what happens is, bad actors internationally will keep track of all these 0 days or all these CVEs, and then look for, they will profile systems. They will go around the internet and look for systems that fit this criteria, that aren't updated, that aren't patched, and then attack them. So it's not necessarily your fault as a developer. Sometimes it's just the actual online infrastructure that you're working with.
Okay. And therefore, in that regard, you're saying that, is it a fair statement to then say that permitting the general public to be part of that defense mechanism by allowing them, and in some instances through bug bounties, structurally encouraging them to make those reports, do you consider that as part of the best practice for security? Or is it just a good to have, or is it just a optional feature?
I would see it as a good to have, especially if it's a very public platform. If you're operating a very public platform, I wouldn't expect you to rely on bug bounties. I would expect you to have it there, in case something slips through the cracks. And it does two things. It gives young security professionals a chance for them to try their skills, in a safe, controlled manner, instead of setting them loose on the internet, where they can do God knows what, where, and actually cause crime, actually cause damage, and get arrested. So it provides like a sandbox, if you want to call it, for young security professionals to go, make some money as well, and you pretty much cut their teeth to become the professionals that they want, to end up becoming, white hat hackers or security consultants. So I think it does two things. One, it helps the company, give the position that they're open to change, they're open to learning, and they're willing to work with people to solve problems. That's one. And the other part is it's growing the ecosystem of security assurance and secure application development and security consultants, particularly.
Right. So it's one of the tools in the toolbox for providing security assurance.
Definitely. It's not the primary tool.
Right. It's sort of last defense, right?
Yes.
Right, but it's still nevertheless something that you recognize as being part of that ecosystem of security assurance.
Yeah.
Right. All right. So, thank you very much. I see a question here. I don't know if you may necessarily want to be the one to try and take it. It does ask about the legality, and perhaps we can wait. Maybe I'll take questions if that's okay. I'll take all the questions at the end after all the speakers have had an opportunity to speak. So is there anything else you wanted to add about the perspective on security assurance and how it might interplay with the Act? Because I haven't actually necessarily asked you specifically about the Act from a private sector participant and perhaps I could say owner of systems. Are there things that you think are concern good about how the Act has been set up?
So there are three hats I want to wear in this. The first hat is as a budding security professional, because I was a student of Dr. Busby-Earle back in the day, and he gave us the environment to grow and stretch our leg. So in that context, it's scary for me if I were to find a vulnerability or find an exploit. I wouldn't want to report it. I would want to call somebody. I wouldn't want to report it directly. I'd want to call somebody that I trust who's in the space. I'd call somebody from a company like Simtai maybe, or from T-Tech. I'd call him directly and say, hey, I found this, I don't know what to do. And you just don't call my name. I don't want to get arrested. I don't want to be investigated. I'm fearful. So this is a true story. The second context is in the context of as a software developer, in just browsing about the internet. It really it wouldn't be good for me to find a vulnerability to then go and report it, to then be investigated by the police for malicious, for them to determine if I'm malicious, because it's not something that I think the JCF fully understands. And then as a company, I don't think the law is prohibitive enough. Well, I don't think the law is open enough, to allow, people who are out there who like my platform, for example, who like the technology and the services I provide. The law isn't necessarily structured in a way for them to help me. So it puts the responsibility on me, which is not bad, but it doesn't allow me further options to ensure that the application I'm using or the service I'm providing are in a secure fashion. And this is something that it's the final hat now. As the deputy president of the JCS, I sit on two other boards, the Jamaica Software Developers Association and the Caribbean Cybersecurity Task Force. These are all led by Jamaicans with regional impact. Some of the professionals in those groups as well, we've had tons of discussion around it internally about how the law is interpreted and how, some people have had bad experiences with the law. They've gone through proper channels and done proper disclosure. But, at the end of the day, police come to their house to interview them. It's very intimidating, especially if you're like between 18 and 23, living with your parents. One day, police open up and they come for your son or they come for your daughter. That's terrifying. So it would be nice if, as Lieutenant mentioned earlier, if the law could be structured in a way to allow, like a discrete disclosure one and, the whole bug bounty program. So those are the three different contexts I'm coming from.
Thank you very much. Thank you very much, Mr. Scott. I understand you mentioned TIE just a while ago. You also mentioned T-Tech. In fact, we have representatives from those. Perhaps since we're on the private sector segment of this, I don't know, Mr. Andrew Nooks or Mr. Christopher Record, would you be interested in making on this at this time? Mr. Nooks, I see you have.
Hi, good afternoon, everyone.
Good afternoon and welcome. Let me ask you one pointed question. Not just pointed, but from your perspective, okay, maybe I'll allow you to share with us why Simtai would have a perspective that we should pay attention to. And then I would ask you to share with us what your perspective on the hindrance, is it a hindrance or a help? What is the impact of the Cybersecurity Act as it's defined in terms of providing security assurance?
Well, I should have known when I decided to log in that this would come, and then I saw Jason on the call, and I was about to just jump off because I know Jason would have mentioned and bring us into the spotlight. But
this is not to embarrass you, so please feel free.
That said, in terms of the Cybercrimes Act, we looked at it a few years ago, and it's one of the things that we so our young professionals, the moment they are contracted by Simtai, the moment they are employed, like, you need to be familiar with this act, because as a professional, and even one that is formally engaged by an organization, there may be implications if you step outside of scope. I'm
sorry, can you just remind everybody why employees at Simtai would need to be particularly careful? What is that
apologies.
Simtai does?
So Simtai Consulting has been in the space of technology for over 23 years. We are one of the leaders in cybersecurity services across Jamaica and the region. And we have, one of our primary focus is testing systems from the ground up, testing applications, providing assurance or reasonable assurance to whether it be a development company or marketing company.
So information security. Information security is your core, is part of your core business.
It's a part of our core. It's one of our core verticals in the business, and we've been doing this for quite some time. So we have interfaced with a lot of companies from different sectors.
And you just said that the Cybersecurity Act is one of the first documents that you present to your new employees and say, pay attention to this.
Yeah, it has to be, because even as a consultant, there's a bit about being authorized, and there's also the bit about scope.
Right.
So you're authorized to perform particular actions, but you're authorized within a particular scope. We always say that you get employed to do something, to behave like, to use the same techniques as someone malicious, but you're asked to use your right hand and hold your left ear and your left hand and hold your right foot.
Yes.
In other words, you're basically tangled up and say, persons are saying, we want you to produce as best as you can the results. Stepping outside of the scope can land you in trouble. Most of your organizations they are reasonable. Most of the organizations work with, they're reasonable. So if we realize that we're stepping outside of scope, then we'll probably alert the relevant contact to say something is happening here. There are times when you go on a system to test, and that system may have linkages to other third-party systems. And whilst testing, you discover the third-party system. If you start probing that system, it could be a violation because you're stepping out of scope. So it's very important that they our consultants understand scope and understand when they need to stop, make a check, and before they proceed. So from the Cybercrimes Act perspective, it could criminalize a legitimately authorized person looking at a system.
Right. Okay. Thank you very much for that intervention. I don't want to put you further on the spot, but I'm gonna give you a question to think about. That we can come back when we get to the discussion segment of this, and that is, what recommendations might you make, given that we've heard that the act is about to go under review? I think perhaps we might find that many of the interventions made in this discussion here today hopefully might find their way having an impact on that. And so perhaps as a key player in that space, I think it might be wonderful to get that kind of feedback from Simtai. Thank you very much, Mr. Noakes.
You're welcome.
I don't know, does Mr. Record care to make a comment? I mean, I don't mean to put you on the spot, but it was a courtesy that we thought you might appreciate. I'm not seeing a response to that, so that's fine. This is not meant to embarrass anybody. Okay, let me move on to our third panelist, Dr. Busby-Earle. As I had said in the introduction, it's a colleague of mine, so feels a little stiff for me to be sort of referring to Dr. Busby-Earle. Curtis, as I mentioned before, so your research area is in security in general, right? Cybersecurity in particular, and you're a senior lecturer in our department. So I guess from your perspective as understanding the best practices, the knowledge that goes behind this, the competence that needs to be developed, and what tools, how we teach it, and so on. Maybe your perspective might be, I can sort of get a similar perspective, but not the practitioner's one from you. For example, what can you tell us about the development? So kind of extending that question that I had put to Jason about whether in fact, when you see these examples of vulnerabilities, that's just, incompetence on the part of the developers. What can you say about that? Why is it so difficult to guarantee a software system against an intrusion? Why is it just not possible for us to say, look, bulletproof, it will not be penetrated?
Oh, well, hi, Daniel, and hello, everyone. Good afternoon again. Two interesting questions. So the short answer as to why we can't guarantee that something is impenetrable is that no system is completely isolated. And what does that mean? That means all of our systems, all of our contemporary systems are connected in some way to something else. And they're all very complex systems. So there are multiple layers. There's the layer at the network level. There's the layer at the application level, for example. There are other protocols that exist. And historically, for example, many of those protocols were developed with the expressed intention of sharing information. Decades ago, it never occurred to anyone about this idea of security. And so they were built with the idea of sharing. Now, we develop applications, we develop them at the highest level, at the highest layer. And that means that they are still impacted all of these other bits that form the environment, the operating system, the platform, the hardware platforms upon which they are developed. And all of those are opportunities for flaws or vulnerabilities to exist. And as Jason had alluded to earlier, you can't always put the blame upon the developer. And that's because the developer doesn't always know about all of these various aspects, about the underlying protocols that exist or what is written in that protocol that enables it to perform its functions. And so in order to find those types of flaws and vulnerabilities, one has to have an in-depth knowledge and understanding of both the application and the entire environment upon which that application is built. And so it's something, for example, like you find that a password or set of passwords are being sent in plain text.
Right.
That means that they're not being encrypted in any form or fashion. That maybe you could say the developer should have thought about that, because that's nowadays a fairly rudimentary aspect to securing a system. But if it is that there is a flaw, let's say in the transport layer and the security protocol that's used there, that isn't actually on the fault on the shoulders of the developer. The developer, as what he is or she is tasked with, doesn't necessarily include analyzing all of these different aspects that provide the services to your application. And therefore, it's almost impossible, one,
So
it's always the fault of the developer, and two, to completely make any system impenetrable.
let me try to capitulate one element of something you said, just for those who perhaps have never developed any piece of software in their life, just to kind of understand what's going on here. It's a little bit like I might have an adapter, like a 9-volt, an adapter I plug into the wall and I get a particular voltage out. I don't know how that works. It just happens to work. Right. And if it's flawed and it produces a wrong voltage and burns my device, if I sold a device that I built that used the right voltage, but what came to the wall was bad because the adapter was producing a bad voltage, I'm not really, it's hard to say I'm the one at fault, because it's really the adapter that should have been producing the right voltage. Yes. So I think what I hear you saying is that software developers are working with components that they can't necessarily see what's inside all the time. And sometimes they trust those components, and then maybe the vulnerability is actually inside that.
Yes.
Okay.
Yes, and so there's another dimension to it as well. And that dimension, since you specifically raised the developers, this may age some of us. Long ago, they had these things like ham radio enthusiasts and those who would tinker with electronics, and so they're not engineers. Well, many of them weren't engineers. They're just enthusiasts. They like this thing. They're interested in it. They teach themselves how to do something. There are also developers who are enthusiasts. They didn't have any formal training, for example, in software development or in software engineering, but they're interested in it, and they write applications that may be targeted towards solving some particular problem that they have. But because of their lack of exposure and understanding of what it takes to develop professional software systems, they may unintentionally either introduce or be unaware of flaws in how they go about developing those things. As opposed to someone who has been professionally trained, it is less likely, but that does not eliminate the possibility for flaws to be introduced.
Okay, so as you said, that who's been professionally trained, so does that then mean that within the body of knowledge that we teach and competencies to, so knowledge, skills, and dispositions, is it that there are in fact best practices that can help us avoid some of these problems that you say might be inadvertent?
Certainly. When we're developing software, there are techniques and approaches that can be incorporated that help us to make our systems a bit more robust. And the vast majority of them are included at the earliest stages, which is when we develop the requirements for a solution. And so there are things, for example, like attack trees and the inclusion of UML-sec, which is a version of the UML that focuses specifically UML, the Unified Modeling Language, yes, which is a fairly widely accepted language that's used to develop software. But there is something that's included that helps one to focus on security-related issues. There are things like misuse cases. There's a wide range, and the idea is to help a developer or a software engineer in thinking about potential flaws that could be introduced or that may exist in a bit of software that is being developed as a solution to a problem. And it still, for example, would require someone that has some knowledge of security, because that person can then, based on the application or the solution that's being developed, can say, well, in this space, these are the types of incidents that you tend to find, or these are the types of attacks that you tend to find, and these are what provide the opportunity for those attacks to happen. So do this or include this bit of code in your system.
Okay, so what you're speaking to there is the value of having the formal training and education in the space. So yes, you can do a lot on your own by just pulling together bits and pieces, but there's all this knowledge behind that informs you about which components might be appropriate for which contexts.
Correct.
And when you ought to be paying more attention to certain things than others.
Yes.
So that raises an interesting question then. If you go from the other end where vulnerability is discovered. So we've just covered the fact that not all vulnerabilities are signs of negligence, because what you're really alluding to, it sounds like there's a lot of complexity involved. The computer systems that we code for are massively complex, even within a single computer. But then the fact that it's networked to millions of other computers creates a far more complicated environment that then, and complex actually separately, that then creates the opportunity for the vulnerabilities to arise in a way that perhaps would have been very difficult to have anticipated. So there's complexity as a source of one vulnerability, and then there's negligence, as we mentioned earlier. Question, is it possible, based on the vulnerability after the fact, to determine which of those is responsible for that particular vulnerability?
In most cases, yes. Because when we analyze, or if we have the opportunity to analyze the attack, and we're able to find that vulnerability that provided the opportunity to launch that attack or to find that weakness, then we could analyze code, possibly, or the source code that was involved, and then see if it was something in the application itself, or as we had made mention of earlier, it could have been in an underlying protocol or something in the operating system, where the combination of what was written in the application and what exists in the operating system and the platform provided the opportunity for this vulnerability to occur and to exist. And so it is possible, yes, to determine whether it was due to negligence or some other.
But the way that it would be done would in fact rely upon being able to examine the code that is executed and perhaps a configuration for the deployment. And you have to be able to get into the system, into the goods.
I mean, if you only have a binary there, I've also seen research, and it's from years ago, where you can take binaries and reverse engineer binaries to get the code that was used to generate that binary, and therefore perform an analysis upon it to determine some.
And for the benefit of those who don't know what a binary is.
Right, so that's the bit that actually runs.
Right. And developers don't actually write. They don't write code in binary, right? So
no, they write in some language, and it gets changed or converted into something that then gets executed. And at that point, you no longer have direct access to the source that was used to generate that binary.
Which means you don't necessarily know what the author actually wrote, because at that point, you may have all the libraries that they may have used, all the various components they may have used, all the various extra pieces that they relied upon. All of those are collapsed into that binary at that point in time.
Right, and so that makes it a bit challenging to perform an analysis if the source code is unavailable.
Right, but it sounds like if there is indeed, let's say it's a matter of something going to court, since this is about the Cybercrimes Act, and there's a question of, is it a question of negligence, or is it a question of really just unavoidable best practice happening to have that vulnerability? You're saying that an investigation, when the source is available, could, in some cases, could make a distinction between those two causes?
The quick answer is yes. But see, in such circumstances, well, that's also where forensics comes into play, and looking at what actually existed on the device or devices that had been used to conduct the attack or the or committing the crime, whatever is being discussed in the court at that point in time. So there are a number of other elements that would form part of the data, part of the evidence that could be used in the determination of what was the root cause of this particular incident.
Okay, very good. Thank you very much, Dr. Busby-Earle. Perhaps I will ask you for your final thoughts on whether, in your opinion, from an educator's perspective, whether in fact you believe that the way that the Cybercrimes Act is set up does in fact present an impediment even from a teaching perspective, or is it not an issue for an educator?
No, it is. That's the thing that I also discuss. Before anything happens, you see, the thing is, 9 out of 10 students will come and they say, "You're going to teach me how to hack?" You know, at that age, there is a lot of curiosity.
Right.
They have a lot of skill that they have recently acquired from the courses that they've they took part in over their earlier years, and so there's just a lot of energy. And so I use that not just to guide them as to what exists in terms of the law, but I also make sure that they're aware of not only what the various acts or offenses would be, but in order to try to give them an appreciation for what could happen, I make sure and mention the fines, the potential jail terms, the fact that there's, in my opinion, a lot of ambiguity in terms of what could be construed as, for example, someone who may be aiding or abetting, to use my terminology. You know, I could lend someone my machine, my laptop, and that person then uses my laptop to engage in some illegal or criminal activity. I may be questioned because I may have been aware of the fact that they may be using this particular machine or device to engage in those activities. And so it is somewhat of a hindrance because it limits what we can do in terms of allowing a student to use some of the skills that we teach them in the courses. We have to find ways of sandboxing it.
Sandboxing, right.
In past years, we've developed or we've used platforms that are completely independent and aren't used in any day-to-day activity or enterprise to demonstrate things, for example, like how a worm performs, what does it do, how do you know what malware looks like, how does it behave, those kinds of things.
I put it to you,
put them in any jeopardy.
But I put it to you that everything you just described is what you would want to do anyway with students who are just learning. Yeah. And then also when they come with that enthusiasm for hacking and so on, I mean, that is coming from a context of hearing about these incidents and actions that occur elsewhere. And they're now curious to learn more about how that works. So isn't that also an opportunity to inform them about the ethics of what they're doing and the knowledge that they're learning and the competences that you're trying to teach? And that in fact, the Cybercrime Act is there to point that, you know, beyond just simply ethics, you could in fact be breaking the law if you were to, you know, be a bad actor. Yes. So it's in that regard, that's not a bad thing.
No, it isn't, and it's as I say, I use it to ensure that they understand where a line exists. That if you cross this line, now getting into the realm of illegal activity.
So that part is fine, but what about the part of the like what we're talking about, the bug bounties, the being a good actor, reporting a problem? Does that encumber any kind of education and from educational standpoint? Is there an encumbrance there?
Well, since that can't happen here in Jamaica, then no, it's not really encouraged. It's what's encouraged is get something in writing that permits you to do X with a particular person's system only upon receipt, and it has to be signed by someone who's authorized or unauthorized representative of that entity, that you can then consider doing something, and you should also explicitly state what that something is.
But in that case, meanwhile, the system remains vulnerable.
Yes.
Okay, so
we discussed earlier.
Yeah, right. So we'll come back to that perhaps in the discussion. Thank you very much, Dr. Busby-Earle. Let me now move to our fourth panelist, Mr. Andre Sheckleford, who will hopefully provide some legal perspective on the discussions. Welcome, Andre. You're a former student of mine, so, but you know, now you're a big man now. So, Mr. Sheckleford, attorney at law, we're very glad to have you on the panel. I understand you have a presentation that you would like to share.
Yeah, evening, Prof. Evening, everybody. Evening, fellow panelists. Good evening to the viewers. And it's interesting, this whole conversation and how it's developed. I had in my mind the question of whether it'd be better for me to go first and lay the legal groundwork, or go last and discuss the context that has arisen. And I certainly think going last is best, because the discussions from each and every single panelist has engaged different aspects of the discussion. Because the reason why I have a presentation is that the focus isn't on the Cybercrime Act only, even though that's what's been thrust into the public consciousness by the recent events, but also the Data Protection Act, because that actually brings up very relevant matters, not only with respect to offenses like criminal behavior, but also from the side of the, what we call the data processor, so the organization and what may attach to them. So these discussions around negligence, are you setting up the right technical framework, so on and so forth, come within the context of the Data Protection Act. So I'm going to have an opportunity to talk about that as well.
Right. No, I mean, we're aware that there is a Data Protection Act, and that in and of itself has many more implications for what an organization that has information, especially information that might be available to the public, what kind of responsibilities they take on when they do that. But that in and of itself could be a whole nother forum. So, yes. And in fact, and I'm sure we have Mr. Chukwuemeka Cameron on our meeting as well, and I'm sure he would have more than a mouthful. He could give a whole day workshop on that. So, but I would very much appreciate your perspective, and I'm going to allow you to start your presentation, but I do want us to remain focused on the issue of how the Cybercrimes Act as defined may or may not, and we'd love to hear a legal perspective, impede and impact what we consider best practice for providing information security assurance.
No problem at all. And I would say to that, because the answer to that is quite short, I think it's quite an impediment because of the wording of that. So let me jump in and just
yeah, please go right ahead.
Right. And as I said, the latter part of it, I won't focus on to any great extent, but the main focus of the discussion would be the line of criminal prosecution that can take place for someone who goes about this so-called ethical hacking. That is someone who has a bona fide interest in working out the difficulties in a system or the vulnerabilities in a computer system. And there are two routes for that, the Cybercrimes Act and the Data Protection Act. And I'll very briefly talk about private actions that can come up, how someone whose data has been breached or whose system has been subject to a vulnerability can raise a private matter as against the quote-unquote hacker. And there are three routes for that: breach of confidence, invasion of privacy, and the Data Protection Act. And before I get into any discussion about them, what we have here highlights a major weakness in the Cybercrimes Act, in that every other point I have on the right-hand side of the screen has within it a context or a discussion or a consideration of public interest. The Cybercrimes Act doesn't have that. The Cybercrimes Act is very bland, and it says unauthorized access, criminal behavior, subject to prosecution. So let's have a look at the Cybercrimes Act. So the Cybercrimes Act is really based on the UK the UK Computer Misuse Act of 1990, and you heard that right, 1990. So our 2010 legislation was based on legislation which came about a good 2 decades before our legislation came into existence. And that 1990 Act in the UK was passed in response to a decision of the highest court in England, and the highest court in the UK, I should say. It was formerly called the House of Lords, and it was in two decisions: the Queen against Gold and the Queen against Schifrin. And in a nutshell, I won't bother go through all these bullet points, but in a nutshell, the defendants in these cases had hacked a system, hacked a telecom system. They hadn't done it for any monetary gain or anything, but they wanted to show off their skills as hackers. So they went about and they hacked the system, and they accessed the information of various subscribers, including the Queen's husband, Prince Philip, Duke of Edinburgh. And they were prosecuted, and they were charged under a forgery-based legislation, the Forgery and Counterfeiting Act. And their convictions were eventually overturned by the Court of Appeal, and that was upheld by the House of Lords. And the reason for that was because their activity didn't actually fall within this Forgery and Counterfeiting Act. So what the prosecutors had done was to try and fit, a square peg in a round hole. So they had a certain set of facts, question, what can we charge these people with? They went to this forgery bit of legislation, but the fact is that the forgery legislation wasn't fit for purpose, and hence the Computer Misuse Act was passed. And that Computer Misuse Act has been subject to some amendments, but no major overhauls, and it sets out a certain set of offenses. And the one for our discussion really is the first one that's listed here: unauthorized access to computer material. And the Jamaican Act copies to a large extent some aspects of the Computer Misuse Act. Everything with a green dot has a very strong analogous provision in the UK Act. Everything with a purple dot comes from somewhere. So you don't quite find analogous provision in the UK Act. So the main one for our discussion is Section 3 of the Cybercrimes Act, which prohibits unauthorized access to computer program or data. And the issue here is the wording of the provision. So this is what it looks like. A person who knowingly obtains for himself or another person an unauthorized access to, I'm guessing that's any program or data program held in a computer, commits an offense. And a breach of that can lead to as much as 7 years imprisonment plus a fine. Now, that's quite a blanket statement. If you knowingly obtain for yourself or another person unauthorized access to a computer system, you've committed an offense. And this naturally blankets ethical hacking as well, because there's no restriction, there's no exception, there's no exemption. It's once you knowingly obtain unauthorized access to a computer. So, as I said, unethical hacking will engage the authorized access provision, that's Section 3, and there's no qualification to that. And as I said, the Jamaican provision is pretty much the same as the UK provision, and there have been calls in the UK as well for some sort of defense in relation to vulnerability research to be put into that. It hasn't taken place as yet, but there's still calls in that jurisdiction as well. Now, this isn't the only approach you'll find in the Commonwealth. I'd say across the Commonwealth, there have been several similar enactments which are similar to the Cybercrimes Act. And throughout the Commonwealth Caribbean, you'll find very similar acts as well. You'll find some jurisdictions which have gone another way, and an example of that is Barbados. In that Barbados has adopted the proposal that's put forward through the Commonwealth, the Commonwealth Office of Civil and Criminal Justice Reform, in that they've put together a model act and said, hey, Commonwealth people, you can have a look at this act if you want some ideas. And that act includes the phrase, without lawful excuse or justification. So a person who intentionally, without lawful excuse or justification, accesses a computer system will commit an offense. So that bolded phrase, without lawful excuse or justification, would provide a defense for someone who is adopting this ethical hacking. You're simply saying, I'm doing vulnerability research, I'm testing this system, that's all I'm doing, I have no malicious intent. And as I said, Barbados seems to be one of the few Caribbean jurisdictions to adopt that approach. So really, at the end of the day, ethical hacking in Jamaica would appear to be a breach of Section 3 of the Cybercrimes Act, based on its pure, simple wording. So the matter is then left to one of prosecutorial policy or prosecutorial discretion. Will someone be prosecuted for that type of activity or not? In the UK, I haven't seen any reports of any prosecutions or convictions in relation to ethical hacking. I don't know if it has happened, maybe it has, but certainly from this doing some rudimentary searches around news reports and case reports, I haven't been able to find any such thing. And the truth is, across societies and across the Commonwealth, you have badly drafted legislation. It does happen. And you do find you have legislation that criminalizes conduct which really ought not to be criminalized. And it's then left to a matter of policy. Should we really prosecute someone for this or not? And sometimes the answer plain and simple is no. And that seems to be the guiding policy from the source of this norm, that is the UK. But we have a cause for concern in Jamaica. The response to the Jam COVID breach, what was said, and how ministers of state started coming out and saying, hey, that's a breach of the Cybercrimes Act, we'll run down people for things like that. So that state response, though the DPP's office is to be independent from the executive, that's the people who run the government, the ministers, so on and so forth, that type of thinking can certainly spread, and it's not implausible that people may start to be prosecuted for things like this. If you had asked me some years ago if someone would be prosecuted under the Cybercrimes Act for saying something bad, I mean, it could be something awful, but saying something bad about somebody on Facebook, I would say absolutely not. No one would pursue. I would go down a line like that. But you may remember that a few years ago, a young lady, I think her name was Latoya Nugent, she was threatened with prosecution, and it went really far down the pitch in terms of the prosecutorial process in relation to her. So we can't sit on our hindquarters and rest and hope that prosecutorial policy won't go a certain way. I would say the act should definitely be amended, and I'm glad it's coming up for review. This is something which most definitely ought to be raised for consideration. Oh, very quickly, Prof, I know you wanted some focus on the Cybercrimes Act, but hacking also engages the Data Protection Act in the context of a criminal offense. So I just want to focus on that very quickly. As a broad outline, how the Data Protection Act works, I mean, it's a very long bit of legislation, seemingly complex, but when you get it down to its nuts and bolts, it's something which can be understood fairly easily. And at its core, it provides a set of standards by which personal data of any individual ought to be processed. It creates certain rights in relation to individuals and the personal data, and it creates this enforcement and oversight mechanism as to how people's personal data is processed. And the main thing I want to focus on is one of those data protection standards, which is often referred to as security, the security standard. And at the core, the security standard is that any organization or person that's processing personal data, and personal data is any data that's obviously about a person, you can think about it like that. Once you're processing personal data, you have an obligation to put in place technical apparatus to secure personal data. And within the context of that discussion, there's an offense which could attach directly to hacking. And that says at section 37, a person who willfully and without lawful authority uses any means to breach any encrypted personal data commits an offense. So on the face of it, it would seem that if you attack a system, you hack a system, and you access any personal data, you would have committed an offense. But there's a bit of nuance sprinkled into the provision in that at section 38, it says a person does not commit an offense under section 7 if the breach is justifiable in the public interest. And naturally, bona fide ethical hacking would be in the public interest and therefore fall within that provision. So you have the Data Protection Act, our Jamaican one being based on the English Act as well, which does provide this sort of safeguard for the hacker who's doing something is vulnerability research in the public interest. And then you have the Cybercrimes Act, which is a bit of a blunt instrument and saying, once you once you access someone's system in an unauthorized fashion, we're coming after you with a meat cleaver. So that's an interesting dynamic. And I would think that this latter bit of legislation, which takes into account more modern practices, ought to really be the guiding light in relation to the Cybercrimes Act. And I'll rest it there for now.
Thank you very much, Mr. Sheckleford. Wonderful bits of information there, very informative indeed. I certainly learned quite a bit a while ago. And in fact, that last bit points at perhaps a mechanism for the way that the Cybercrimes Act could be amended by sort of explicitly saying that action that's in the public interest would not be a violation of the perceived action where it might have been construed as such. So very interesting. I think that I will, maybe you are the person to answer this question that I had in mind. And this is what occurred to me when I read that bit of the act myself. The notion of defining what is unauthorized, if I recall it appropriately, almost seemed to imply that you would know based on what is in the information whether you were authorized or not. And I suppose that when you're dealing with information that's printed on paper, you know, if it's locked up in a filing cabinet inside of somebody's office and you'd have to break through the building, break into the building, break through the doors, get into some secret office, break the filing cabinet, then get in, you could say, even if it's not marked confidential, you could say, no, really, you're not authorized. On the other hand, though, if you now have that data digitally present and it's simply sitting there because it is in a server, but it's not secured, that encounter of that data seems to be considered unauthorized because you're not authorized to see that information. But the means by which I got to it, I didn't breach any particular protection mechanism, digital protection mechanism. I simply stumbled upon it. And it was, in fact, because of how it was presented, as in how it's been put on it, that I was able to do that. In my view, I wondered whether that kind of regard of it could be considered unauthorized, given that in a digital environment, what you would consider authorized versus unauthorized has to do with what role you would have been assigned when you access the system. In other words, if I log on to a system, I have to authenticate, put in my password. And when I do, the system then determines what kind of user I am. I might be an ordinary John public, or I might be some kind of privileged user, or maybe I'm super user, you know, and maybe all kinds of things in between. And each role has all kinds of different privileges of which parts of the system you can access and so on. So if you, as the information provider, put a piece of information in the space that the public can access, digitally speaking, actually authorized to access it, since I can get there?
Well, what I would do is that I'd just back to the wording of the act and just highlight one very small element of criminal law. That's not my practice at all, but just to highlight one small element of it. Each crime is said to have two elements, what you call the actus reus, that's the criminal action itself, and the mens rea, that's the thought element that's ascribed to the crime. So murder, the act, is an act which causes someone to die, and the intention is an intention to kill or cause grievous bodily harm, act, mental element. What I would say here is that section 3, the act is the unauthorized access. And I mean, I'm subject to anybody's sort of view on this, but I would think even stumbling across data which you don't have authority to access may be unauthorized access, but I could see where an argument could be made that it's not unauthorized access. But certainly you'd be okay with the mental element of it, in that the acts as a person who
knowingly. Okay.
So the fact that you didn't know you were doing it when you're doing it should absolve you of any.
Okay. So it sounds like at a nuanced level you might be able to escape a jail sentence, but I think practically, from what we're hearing from Jason earlier, you certainly don't even want to be investigated in the first place just for being a good Samaritan. As right, far as
Jason's example brought to the fore a harrowing story when I lived on campus. When I went back on hall and saw police beating at my door, and I was very, very worried. But it turned out that they came to the wrong block and the wrong. So I completely understand where it's coming from.
Right. Okay. Thank you so much, Mr. Sheckleford. And now I think we will move to the discussion section where we can engage with some of the questions that may be coming. Now we are streaming to YouTube, and we do have a number of questions coming in. Perhaps before I do that, I should, out of courtesy, I did mention that we had Mr. Cameron on. Is he still? Yes. I don't know. You've just heard, I think, a wonderful presentation from Mr. Sheckleford. I don't know. Did you want to comment a little bit on, in your opinion, you have a background in technology and you're a lawyer, so, and you have quite an opinion on the Data Protection Act and quite a lot of advice on that, certainly. But in terms of the Cybercrimes Act and its interference, if it is so, do you have an opinion on that?
Well, firstly, thank you very much for allowing me to be part of this conversation and the panel that I was assembled. I've also learned a lot and opened my eyes and given me a very wide perspective. So thank you very much, Dr. Coore. I'm very grateful for the opportunity to share. So very briefly, initially, when I heard of this situation, I never contemplated it to be a cybercrime issue. And up until now, well, I'm convinced that is not a cybercrime issue. And I'm glad I have an opportunity to share my view. And I haven't looked at the Cybercrimes Act in any depth as well. Suffice it to say, one of the first prosecutions under the Cybercrimes Act was by way of private prosecution, and I consulted on it, and we did get a successful prosecution. So notwithstanding having looked at it substantially for this purpose, we are able to obtain a successful, one of the first prosecutions under this legislation. So I'm somewhat familiar with the legislation. The question, so I was concerned when I heard the government speaking about the criminal offense, and I paid it no mind because I did not attach any weight to it. And I would love us to throw into this discussion from the legal perspective, Section 2 of the Cybercrimes Act, because this whole question, to my mind, of Section 3 and how it is defined does not arise and ought not to be causing this sort of fear and trepidation that it is. And in terms of possible amendments, I think there could be clarity, because for me to have a totally different view from what I've heard exposed, it means there is ambiguity that needs to be clarified. So this platform is critical, and I'm very, as I said, very grateful to be part of it.
Okay.
If I were to look at section 2.2 of the Cybercrimes Act, and
I'm giving you 2 minutes.
No, man. Yes.
That's right. Okay. Yeah.
Section 2.2, it says, for the purposes of this act, a person obtains access to any program or data held in a computer if the person calls a computer to perform any function that, and then it says out what those functions are. So before we jump to unauthorized access, we first have to qualify if it's access under the legislation, and it's only legislation if you access a program or data to perform a function that does something, and that does something is alters or erases or be copies or moves. It actually has to do something before it qualifies as access.
Yeah, but I mean, I hear you, but you see that term copies or moves. Perhaps that is where the reflection of coming from the 1990s is coming through here, because that language is problematic. You see, for you to view a document on your browser, that information has to be copied to your computer, whether it's in temporary storage or what have you. That is a copy in and of itself. And that issue of what it means to copy and to move and so on in a digital environment and so on is caused a lot of angst in the 1990s in US law when they were trying to understand the ramifications of the wording of, especially in that context of dealing with copyright. And so even that wording right there, so doesn't really address or doesn't resolve the ambiguity.
Well, it's that is the starting.
There's actually an English case on the point as well. I'll try and find it in the meantime, specifically on the Cybercrimes Act. It was an extradition matter involving the US and cybercrimes, and it was recognized that the copying or moving to temporary or cache storage, even for display on a monitor, or I might be adding that last part, but movement to temporary storage amounted to copying in the context of access, just to know what Prof.
Okay. All right. So, okay. Thank you very much. Very engaging discussion. And now I don't want to leave out our audience because we do have some persons on YouTube who have some questions. Let me see if they're kind of flying through a little faster than I can handle. Let me start with a simple one. I think we'll see who wants to take this one. If someone comes across something like a 0-day vulnerability, that is the one where it's sort of embedded in a tool that you're using, or system that you're using, but they're aware that they will not be rewarded a bounty for making the vulnerability known. Is it illegal to sell knowledge about the vulnerability to a third party? Mr. Sheckleford, you want to take that one? That's you. When you stop laughing.
I would say, that would, yes, it would be unlawful because, or it would depend on what the third party does with it. Because if the third party does go ahead and commit an offense under the Cybercrime Act, you would have aided or abetted such an offense. So yes.
Right, and not, I mean, we can say that's highly unethical.
Certainly.
Yeah. Okay. Oh, Mr. Scott, comment?
Oh yeah, definitely. I had a comment. Definitely.
I see your hand up. That's why.
That is highly unethical and common practice on like the dark side of the internet, where you will sell knowledge of systems to be exploited on the darknet. So yeah, I mean, I was following the comments in YouTube as well and answering them there. So yeah, that's not something I'd encourage. I mean, even if you're not going to benefit from it, it's always nice to help out somebody who doesn't know.
Okay. I see a second question, which looks like a part of a question. I'm going to need some context to clarify this one. It has to do with if data is saved in plain text and no breaking of encryption is required to access the data, but the rest of the question is not there. And I'm wondering if that was in the context of perhaps it was in the unauthorized access. I wish I could get some clarity on that. Is that, I think the question there would be, is that a breach? Would that be a breach of the Cybercrimes Act? So a service provider has some sensitive information. They did not encrypt it. Somebody gets a hold unencrypted data, and so in a sense it's unauthorized access because they're not supposed to have access to that, are they liable? Right, that's another lawyer question.
Well, that raises issues on two fronts. On the side of the access to the unauthorized data, once again, it's knowingly accessing the data because of the language that we have. Yes, that would be a breach of the Cybercrimes Act. And on the other side, about not encrypting the data, that would engage the Data Protection Act. That's a failure of the data processor to put in place proper security measures.
Right. So, right, and that's the thing. Under the Data Protection Act, there's a clear liability or responsibility on the part of the data processor to put in protection mechanisms. Right? And I know Mr. Cameron can speak at length to that. So when things like that happen, especially if you can show that the vulnerability is there because somebody overlooked something, there potentially is liability there. Well, Chuck, you want to comment on, I think on the DPA that we've clear, on the Data Protection Act, that's clear.
There's no liability for any data processor under the Data Protection Act.
Oh, really? So
yes, that was a mistake on my part. Data controller.
Oh. So I see. So all the liability is shifted to the data controller.
The criminal liability, and that is why they mandate a data processing agreement to ensure that liability is passed contractually to a data processor.
Wait, to a data controller?
No. So there's no criminal liability. There's no liability under the Data Protection Act for any data processor. But that is why the Data Protection Act mandates a data processing agreement so that
with the data controller,
between a data controller and a data processor, so that liability, contractual liability, can then be passed to the data processor.
Okay. Under the Cybercrimes Act, would that have been a problem, not protecting information?
No, that doesn't arise under the Cybercrimes Act. And for me, you have to cross a hurdle. And in terms of amendments under the Cybercrimes Act, that section 2, that says you have to do some function, you have to move it to another location. I think that's where the legislation can focus, because it's pretty clear here that you have to cause some function and move it outside of its original location. So neither under the Data Protection Act or Cybercrimes Act, through my eyes.
Okay. No, I very much appreciate that the input. Mr. Sheckleford, you had an opinion on there was something else you wanted to come back on regarding the protection mechanism in the Data Protection Act. Is that a comment you still want to make? You're on mute.
Sorry about that. I was having trouble unmuting myself. It wouldn't be an extensive comment. It was just on the question.
Go ahead.
The question on negligence, not negligence, so on and so forth, which arose. The security standard in the Data Protection Act, as I said, puts an obligation on the part of the data controller to put in place technological and organizational mechanisms to ensure that personal data is protected. And within that context, you would imagine that one is expected to keep up to date with modern practices. And on top of that, and just in terms of definitions to help, the data controller is the person who essentially determines the fate of the data. They say why the data is being processed. And the data controller can also be the data processor. That's the person doing the processing, or that can be something else, so a third party. And in that context, where components of processing is outsourced to a third party, the data controller is under an obligation to ensure that that data processor can guarantee the security of the data. So just to throw that into the mix.
Okay. Are there lessons from how that is structured that perhaps should be taken over into the Cybercrimes Act in terms of what constitutes adequate measures to protect the information? Is that needed in the Cybercrimes Act? What might constitute adequate measures to provide information security assurance?
Well, as I understand it, oh, sorry about that, Chuck.
Remember, you are really looking to prosecute criminal behavior under the Cybercrimes Act. the data protection, so there are negative incentives set out. Under the Data Protection Act, there are these positive things that you have to do. And what they have done is criminalize the failure to take those positive actions. So it would be an overkill now if you would actually criminalize software development.
Yes.
Because that is in effect. So what they have done through the Data Protection Act is to say, okay, you are spending money to build this application. You have a responsibility to ensure anybody that you engage does what he's supposed to do. What you need to do is look at some independent third-party international standard. So the languages that we heard Curtis, Dr. Busby-Earle speaking about, there are international information security standards that you can seek to comply with, measure people against. So it may be dangerous if we want to import into the Cybercrimes Act any further data processing or software development standard. That goes contrary to the direction I think we want to go.
Okay. I appreciate the point, and that's useful from that you're exactly right kind of people to be advising somebody like me who's just pontificating, in the wild. I don't know anything about how laws are made. So that's very good correction there. I see, so Scott wants to say something, and then.
Yeah, so my comment and question based on what Kramer just said is as a software developer or as a service provider to a company, if I develop this system in compliance with with best practices and whatnot, and at the end of my contract I hand over a system with the relevant documentation to show that it was built in compliance, it works, it's secure, it's nice, it's fine, and then I hand it over to my client, and thus ends the agreement, and I move on to another project. If that bit of software is now in the hands of my client and it becomes compromised, where does the responsibility lie? Because that's a question I get asked a lot. One, and it's something that it's frequent here in Jamaica. Work is done. The work is verified by some QA or verified by some standard, and then the work is handed off, and then the people leave. So in a case like that, Chuck and Andre, how would the DPA or the Cybercrimes Act work?
That's an excellent question, and I think we need clarity on that issue. So if it is you are commissioned or contracted to develop a piece of software as a work for hire, and you assign all the intellectual property to that third party, who then becomes that data controller, you are free of all responsibilities under any Cybercrimes Act or Data Protection Act. You built a tool, you sold the tool, you have nothing else to do with that tool, even if it was poorly constructed. So they looked at it, signed off on it, and accepted it as their own. It now becomes their own. However, when you now want to still retain the intellectual property and license that piece of software to that third party, even if it is running on their equipment, that is when you still remain the data processor and you remain liable for the maintenance of the application. You heard Dr. Busby-Earle talk about the network layer, the application layer, and the data level. You remain responsible at all material times for that application that you built. So that's a very important question and understanding I think we need to have.
So based on my experience in the market right now, a lot of companies insist. I have several contracts right now. I'm looking. They insist that the companies itself who are contracting, so those are seeking work to be done, insist that the IP and everything be handed over to them and is their responsibility and sold. So they are now assuming all this risk. This is what you're saying. So you're saying that they should leave it with the vendors and
well, if they know what they're doing, depends on if they know what they're doing. Yeah. Anyway, I see a hand, Mr. Budram, Matthew Budram. Is there a question? I see a hand from you.
Yeah, hi guys. So I guess a general comment. One of the things that I've been thinking about is that we should start making provisions for white hackers, bug bounty programs, and that has been the common consent. sorry,
white hat.
Right, and that has been a common consensus in the whole discussion. But maybe an approach where, just like in the U.S., where where they have what you call it, lobbyists, or even being registered as a foreign agent in order to engage with anybody. That has been a mechanism that works in the US. Maybe something like that could work here, where you register a person as a white hat hacker, and just drawing on some of the things that Mr. Nooks had mentioned, define a scope in registering. What am I looking at? And based on all of those components, then if you're investigated and found to have some, access to something, then provide the relevant information to show that you're an authorized party. Maybe it would be through the.
So it sounds like what you're suggesting is some kind of license to hack, so to speak.
Yeah.
But
exactly.
there's an issue of scope. Scope is per job. I see that Mr. Nooks would like to respond. I'm going to let him respond to that.
Yeah. Good evening again, everyone.
Yeah.
From the perspective, I see a question in the chat asking about bug bounty and if it is legal for a Jamaican entity to have a bug bounty, and I'd love to hear.
Well, hold on. I'll come to that.
Okay, cool.
But I thought you were going to respond directly to the question that Mr. Budran posed. That's not why you raised the hand.
No,
so.
It was because I was actually getting to that. But as it relates to registering, and I've heard the talk about registering ethical hackers. There can be partnerships. There has to be a context in which any kind of a bug bounty program is going to be made nationally, because persons will go under the cover of a bounty program to do other activities. And so organizations have to be careful when they decide that they're going to launch. The organizations that does that successfully have taken, as Curtis mentioned, the necessary steps to protect all layers of their systems, and they're just now looking for someone to help them to find the things that are not clear and apparent. So they have taken the different standards, they have applied the different standards, they have tested their application using contracted hackers. They have their teams in place that are constantly checking and monitoring their systems and everything. So they are now confident that the system is relatively secure. We can now open it to the public to find those little nuances that our technical team, because no knowledge is universal, no knowledge lies with any one group. So we're going to find those persons with those little nuances that is going to help us to even further strengthen our thing. So it is not to be taken lightly. I have a system, I've built it. I don't know, I've never tested the security posture. I'm collecting data from different persons, and just open it to the public and say, come whomever will may come and test this. You're talking about exposure, potential exposure of data, and you don't know who is going to be testing.
Right.
I guess kind of follow. There's one thing. If you're putting people's data online on a production system, I think you're in essence saying that you're trusting that the system is secure and or has some level of security that has been verified and tested. So I'm not sure about inviting people. That data is already should be tested, should be verified to be free from certain exploits. I think the invitation is one of come and try and test my system for these exploits, and you'll be rewarded. It's not necessarily inviting a hacker to come and hack your entire system. If it's a production system and it's exposed to the public, there are things that should be a given.
Okay, I see Mr. Sheckleford wants to respond to you and Dr. Busby-Earle, and then I'll take there's a question pending that actually Mr. Nooks pointed at. So let's go. Go ahead, Andre.
I'll be very brief. It's in relation to Matthew's suggestion about sort of a positive listing of eligible hackers. It sounds good. One difficulty I have with it is that if a private organization wishes to test the system, it doesn't matter if that list exists or not. The life will move on for the private organization, and they may contract whoever they want to test the system at whatever means. The difficulty that arises in relation to public systems, and there are two elements to it. One is that a lot of these e-drives which are being pushed have a very strong political dimension and element to it. And there's a strong feeling on my part, that is, of we're doing a great job. So someone can skew information in a certain direction by just simply having a very short list of people who want the face of it look good. And the second issue is that with respect to public things like that, creating listings, they stagnate over time. So it may be a hot topic for a few months, and then a few months later, the list never expands. The authorized hackers die or go out of business or cease to exist, and the list is just gathering cobwebs. So those are perhaps the two practical issues I would have with that sort of approach. Specifically.
What I've seen, if I may just make a quick comment, what I've seen countries do, like in the US, they form public-private partnerships with some technical companies that would be responsible for looking at their system. And I think that's what Matthew was possibly alluding to. So the US government would have contractors who would assist them in their overall cybersecurity program.
Okay, that's good. Dr. Busby-Earle, you wanted to comment on that?
I actually wanted to comment on just something earlier that I think is a very important point that Mr. Nooks and Chuck and some others have been making. And over the years, for example, the government has, I would say, encouraged, for example, open source development and open source applications. And this thing of encouraging others to take a look at software that has been developed, because I think, as Andrew had said, no one person has all of the knowledge. There may be a number of people that have either experience or knowledge about a particular type of system that's being developed, and therefore may be able to provide some expertise in hardening that system. That sort of open source development or encouraging others to help me improve my software is kind of the environment that we're discussing, that we would like to have at some level in the cybersecurity space locally, and that does not exist basically at all because of some of these restrictions that exist. I just think that's a very important point that should be.
But it's not so much for the legislation to make it happen; it's the legislation to stop preventing it.
Exactly.
or discouraging it. Okay. Lieutenant Colonel Sterling, I see you want to come in on that. Would love to hear from you. Go ahead.
Right. Thank you, Daniel. The point I would like to weigh in on has to do with this registry of qualified hackers. And it is certainly something that, sitting at Jamaica CERT and looking at the limited resources within the public sector and the myriad of systems that we were forced to manage, as well as those coming online, the hyper-digitization forced upon us, certainly by the pandemic and the different modalities, and the threats that are posed by the remote access to some systems that, while on-premise, may have been fairly secured. The challenge with registering persons, and certainly the difficulty I have faced to date, is it's viewed by those who would otherwise probably be willing to participate as a sort of monitoring mechanism that they're unwilling to subject themselves to. And so how do we take that discussion certainly to probably the academia, where these persons originate or are trained, to say, encourage persons once they develop or acquire the skill set to be available as resource persons. Certainly for the public sector, where we can't match the salaries to get the skill set that is required based on the magnitude of the digital society that we're pushing, but the expertise exists. So how do we, one, create this registry, generate and mature the partnership, maintain a curated list, and ensure that these resources are available to assist government in facilitating the growth of the digital economy?
Right. I think what you're hearing is that if we were to clean up that law to get the clarity, that it doesn't appear to be, a problem for those who would try to participate. It sounds like you would get some very eager or enthusiastic participation from those, from us and our students and our enthusiastic young ones who want to put those new skills that they're learning to the test. So I would imagine that if we could get clarity out of this revision, then in fact you might very much see that relief of resource as manpower. So let me know, I do want to take that question that was asked, and this is, again, I guess, sort of, again, to the legal experts among us. The question says, given the Jamaican Cybercrimes Act, is it unlawful for a Jamaican entity to even operate a bug bounty program?
So that is really a contractual issue. And I may not fully grasp how the bug bounty works, but if it is that a company offers incentives for members of the public to test their systems, they're put an offer, and then someone would just take up on that offer, and that would be a contractual relationship. So there's nothing preventing that whatsoever.
And you would imagine that's not a breach.
No,
of,
not
of
at
the
all.
act.
Not
Right.
at all.
All right.
I'd love to add to that.
Okay. Go ahead. Yeah, go ahead.
Yeah.
Go ahead.
From the perspective, though, if you're going to do a bug bounty for a company, if the data that you have that belongs to the data subject, if there's a possibility that data is compromised in that bug bounty program that you're offering, and the data subject feels vulnerable as a result of that compromise, what happens in that case?
So that is where you have the data protection.
Yeah.
Data protection impact assessment, and you involve your data subject in what the risks are and what controls you are putting in place to mitigate those risks. Because what you're doing is hardening your endpoints and your exposures. So it's just a matter of including, and I'm glad you put it in that context. I heard Dr. Coore stayed away from data protection.
The two are...
No, that's right. You can't get away from it, but I didn't want to, as I said, you could spend an entire day talking about the nuances of data protection.
So part of it is letting the data subject understand how you process their data and what steps you are taking to protect it. And doing a bug bounty is a means by which you are seeking to protect it and harden your data.
My suggestion would be to use using a production-like system, then you don't use real data in those systems if you're doing bug bounty, especially if you're not sure.
Right, and then you're not really running the real system. Let me
I want to add to that discussion about the data protection. One, it would have to be consent driven if it was okay with real people's data, and two, if you're testing the sensitivity to the work that you use from the data.
Right. All right, let me quickly take, I see Mr. Muir, you have a question, and then I think Mr. Scott wants a comment.
Not really. I was just mentioning that you had skipped over the third question from YouTube, which is what if a vulnerability was stumbled upon by a web crawler and indexed in a search engine? How would that be treated? The context was that we all know that there are web crawlers that actually search through Amazon S3 buckets and collate that data. So what would our Cybercrime Act have to say about actual program that is doing this and collecting this type of open data?
In other words, the actor is not necessarily a human now.
Exactly.
Sorry, I might need a bit more context. I may have been out last the ComSci will it's get a better understanding of that. What type of data are we talking about?
Well, it almost doesn't matter. So if you think about how Google or any of these search engines work, they have systems that go around the web, looking at all the various open websites and collecting what we call the metadata from those sites, which when we do searches, it will now look at that and be able to pop back up and say, yeah, this site has, oh, you're looking for information about that TV show Friends? Yeah, this site has stuff about Friends, and this site and this site. So there are other web crawlers out there, not just Google. And there are a couple in particular that their entire function is looking at these cloud storage infrastructure.
Right.
So Amazon's S3 buckets are an example of that, which is fairly common. And a lot of these things are left open. So the data that is inside of these things are therefore left open. So if you have these web crawlers, which are just running around the web, looking at these various open storage environments and collecting the data that is there,
okay,
what would be the implication?
Right. I think the question is posed.
I think you'd have to make a few presumptions. So to say the Jamaica cybercrime would apply, we have to localize the example quite a bit. So let's say it's Amazon Jamaica, for example, or the web crawling service, the Jamaican service, so you can bring into the play the Jamaican cybercrime stack. You then begin to get into that question of knowingly accessing data in an unauthorized manner. And I think this goes way back to Professor Coore's question about what if data is out there and it's stumbled upon. And I'm revising that answer as I speak. As I understand it, metadata is something which a HTTP coder understands is to be available to the world, or whatever other language it is. So if I post an image and I put as the metadata soda can, red bottle, something like that, it's meant to be accessed. And in that context, I would say that if it's accessed, it's then not unauthorized access, so it would fall outside of the scope of.
But let me reframe that question in perhaps a very specific and concrete way. With the Jam COVID data that was leaked, not leaked, it was actually publicable. Let's say it had been stumbled upon by a web crawler. That's what web crawlers do. They trawl the internet. Now, let's say you do a search and you put in a passenger's name who traveled to Jamaica in 2020, and you put in appropriate keywords. You want to know the COVID-19 test, and maybe you put in the passport and the person's name. And bam, one of the hits that comes up is a segment of the information that's stored on that. The person who's accessing that, of course, they went through a search engine. Under Cybercrimes Act, could they be liable? I think that's the essence of the question that was posed.
So, it's much simpler for me. Somebody wrote that code, that web crawler. The web crawler didn't generate itself. So the person who wrote that code will be liable. And as it relates to the third party who inputs searches that public search engine, no, I don't see where any liability can arise because he accessed a public facing.
Okay, and it's interesting. We do need to close up because it's unfortunate that opinion that you just provided actually has in it a huge problem. Because you're going to now say that Google is liable under that because they wrote that color. And in fact, one would then point out that whoever put that S3 server up with all that data very well knew that Google existed and how that search engine gathers its information. So is the liability on the person who allowed that web crawler to access that information? But let me, I beg your pardon. Sorry, okay.
We have 15 minutes more, I think. Daniel.
Oh, thank you. Okay, I thought we had to close up in 3 minutes.
I would like
to, before we close, as a cap, to put some perspective on how we move forward. And in fact, there was a question that sort of asked for that, and that's a loaded question to end on. But all right, so I see Mr. Scott had his hand up from long before. Maybe I'll ask him to come in if it's pertinent still.
Oh,
and
yeah.
then I recognize Mr. Record as being interested in saying something at the end. So go ahead, Mr. Scott, and then Mr. Record.
So in the context of the bug bounties that we're talking about and responsible disclosure, Chuck and Andre and Andrew had mentioned that, you know, it's pretty much like a contract or an agreement between somebody and a company to, you know, feel free to come and take a look within this scope, you know. Don't go attacking these endpoints, don't attacking this way, etc. But when it comes to the government or to public services, for example, you know, the Jamco app was one, and you know, quite a few government websites as well. How would that work? Would I disclose it to JA Crit, CR Crit, yeah, let's call it Crit, to JA Crit? Sure. Would I call Ministry of Science and Technology? Do I call GCF? So that's the first part of my question. And the second part of my question is, how can I do this without having my door kicked down? Because that is the big question. That is something that, like, every as I mentioned it earlier in the conversation, how can we go about, or how can we implement pretty much a government bug bounty program, like a simple one that can allow, you know, responsible disclosure of common vulnerabilities and common exploits that are found on governments in such a way that people don't feel like you're going to come and kick down them door and investigate them.
Okay, so I realize you put another question on the table. So before we take that answer and get perhaps sidetracked, let me see if Mr. Record wanted to come in. And then I see that Lieutenant Colonel Sterling wants to respond, so I'll definitely allow him after Mr. Record. You want to go ahead? Welcome again, and go.
Thank you very much. Hi, Daniel. Thank you very much. Thanks, Gunjan, for inviting me here. Great discussion, learning a lot. You know, I leave the legal stuff to folks like Chuck and, you know, all the other luminary minds. I just, you know, talk about the high-level examples, the questions that are posed to me sometimes when these issues happen. So as Jason rightfully said, you know, when an issue happens, he'll reach out to a number of us, and we all rally around and call each other. You know, I will call Andrew, I call Jason, and then of course, you know, I guess we'll say in Jamaica, well, there's a marketing term, above the line and below the line. And we have to have our below the line conversations first with all the persons who are in the know and who have the connection to the, you know, the legal compartment and all of that, to say, look, hey, discover this vulnerability. You know, we know somebody who know the guy, because Jamaica is not 3 degrees of separation, it's like 1 degree. So we call the guy who we know manage that website and say, dude, you know, you bottom out a door, right? I mean, you know, however you want to say it. And then they scramble, then they fix it, and then we try to either, because we're one community, we then shut the door and then we move on. Or if there's other people, if there was anything actually, you know, any crime committed, then somebody else have to figure that part out. That's not for us, but you know, we within our network try to do that part. The example that was given a while ago, I remember a few years ago, because, you know, as I'm aware of many hats, you know, I was teaching some wine classes and doing one of my research for a topic on some area around specificity of Italian wines. In my Google searches, just kind of looking around, I found some good information and some, you know, some kind of manuals, look like manuals almost. Found them, great useful information, had content, you know, reference to the name of the people, put it on a slide. And then, you know, next week I'm just discovering that, hold on, all these things were actually for sale. But the Google search actually took me to whether it's the bucket or the source of where those things were actually kept. I didn't go there directly. I just kind of searched for some names, you know, specific in Italian, Barolo, this region, and it came back with documents. Of course, I put in my various sub feeds as I want PDF only and all of that. And it came back with these documents, and I'm like, hold on, but I'm seeing all these guys stuff that they're selling. And well, I didn't know they were selling it at the time. I found out like a week or two later that they're actually selling it, because I eventually went to the front of the site this time, and I went and I said, oh, wonder if they have more there. And I realized that, oh, all the things that I already have are actually behind paywalls. But how did I get them? I have no idea, right? And so am I wrong? Am I the criminal here? Or is it Google the criminal? I heard that question and I thought of saying, let me just jump in and share my example of what has happened with me. But
thank you. No, thank you very much. I made up a hypothetical situation and you just made it very real.
Yeah, it's very real for me because right. With all my worlds that I play and I dig into some of these things, but great conversations. At the last, just my closeout conversation is, over the last few years, I've tried to learn to become a simplifier of a lot of these subjects. And sadly, I think these topics are really, really, really complicated for a lot of our audience to understand. And I try my very, very best. And, Jason, I discovered, while I was on the driving up here, dodging taxi men coming up, I didn't hear when my name was called earlier, but I heard that Jason gave a good example around using, I think it's Crime Stop as an example of this bug bounty situation. And I think we have to find a way, our community, so whether it's through the Jamaica Digital and Technology Alliance, the JCS members, all of us come together to figure out how do we simplify this very complicated topic and let it be known in small ways. Myself and Chuck, we have been working on trying to do that very thing with data privacy and, taking out the 8 sections of the law, whatever you call them, again, I don't remember. But and simplifying them in bite size and just spoon feeding them, even creating cartoons,
yes.
Of these. So
certainly the proliferation of what law entails is a different problem, but very important as well. Thank you very much for your intervention. Okay, we're gonna move very quickly. I understand. Sorry, Lieutenant Colonel, before I bring you back in to answer Jason's question, Andre wanted to quickly put an opinion to the question of liability in the web crawler situation. You want to proceed?
Sure, and thanks to Mr. for bringing it back to the table. Just very quickly, I don't think criminal liability attaches in any of the circumstances, whether to the web crawler or the person accessing the data. As I think Christopher Muir said in the chat, crawler is gonna crawl. So just because a index in search engine works upon something which is not protected, no liability would attach to that. And similarly, if you're typing something and you happen across it, no liability attaches there as well. That would map in here the same actus reus criminal acts and mens rea elements, which I mentioned earlier. And just very quickly, if I could squeeze in to answer Jason's last question about what do, we amend the Cybercrimes Act.
Okay, right, and that's where we're gonna go. Lieutenant Colonel Sterling.
So to really piggyback on what Andre and Chris have said in response to Jason, the way you can report these vulnerabilities without having your door kicked in or being questioned is really to engage Jamaica CERT. We are not a law enforcement agency. We're there to do cyber incident response. And where you find these vulnerabilities, we are willing to work with you. If there is a criminal liability when we go through the process, then we will say to you, there is this color here, and we will not just toss you to the wolves. We will actually walk this through and see where it goes. And so that sort of engagement is something we have already started with some people in academia, where we have virtual sandboxes that take us all the way up to production material in terms of pen testing and vulnerability assessment. But it's done so in a sort of organized and agreed way, where we've said to them, look, we don't have the resources to deal with this volume. For your research students, these are the resources that we would like for them to check, and we would like them to do it within these parameters. And so once we can sort of see the results from this engagement, we'll be willing to roll it out to other academic institutions and companies. But what we have to bear in mind is that Jamaicans are going to be Jamaicans. And you give them an inch, they will take a yard. And so what you have to be careful of is that that student does not do work within scope, in class, and then goes home or outside of class and try something out of scope. And these are the finer points that we're working through with this engagement that we have, but we're way down the road and it looks like it will bear fruit. So engage us. Certainly, as long as I am head of JSERT, the police won't kick down your door.
Okay, well, thank you very much for that assurance. And I think ultimately we really want to the crime, the act itself, I mean, that even if you are not dead, we can still be assured that somebody's not going to kick down the door. Let me
Prof, just before you move on, that process has started. This weekend, we will push a general invitation for comments on the existing, and certainly when we meet next, we will take those comments. You will have 3 weeks to respond, and we will take those comments into our deliberations as we seek to move forward with both the review of the Cybercrimes Act and the review and updating of the cybersecurity strategy.
Fantastic. So the comments here are going to have an impact, I hope. Very briefly, let me allow Mr. Nooks. I did promise you an opportunity to come in with recommendations that you might have from your perspective. Did you? Right. Don't feel forced.
No, but my recommendation usually is from the general perspective, and Curtis said it, Chuck reiterated the different layers. If entities want to be secure, they have to practice defense in depth, which means that they have to look at all the different layers of the ISO, the model, the data model, yes. And they also have to, from a privacy perspective, you also have to look at privacy by design. So you build everything into the DNA, from conceptualization to implementation and operation. You always have to be thinking about security. There are standards out there that you can follow. From the perspective of the Cybercrimes Act and the amendment, I know the process have started in terms of consultation by the Joint Select Committee. I know a couple of entities have been invited to comment on that. So I think that there is openness in terms of trying to make things much more improved, and to listen to the comments of public and experts like yourselves. I want to just use this opportunity to say thank you very much to Dr. Mansingh for inviting me. And it is always great to sit with a very knowledgeable group of experts. And it was great to chat with you all. I learned a lot. Thank you.
Okay, fantastic. And those words, I'm not going to put too many more words on top of that. I think we've had a very enriching session. Everybody has said they've learned a lot, which means a lot because they're experts here. So very good, wonderful interaction, wonderful questions, wonderful inputs and opinions. I am very pleased to hear that coincidentally, the act itself is under review. And so in fact, many of these ideas that have come forward will perhaps have an opportunity to have that impact. I see a final question about where will we be given the opportunity to engage. Perhaps there might be a way that can be publicized. I don't know if the answer to that is already available, but presumably that's going to be a public process, right, Lieutenant Colonel Sterling?
Yes, the actual publication will be done this weekend, and it will have all the details. There will be 3 weeks for the responses to come in, and then we will take those on board and get the ball going with our next meeting. Okay, wonderful. And so I think at this point, I really do need to close this. I am very, very happy with the engagement we've had. I hope that the audience out there has had as enriching an experience as us who have participated in the discussions on Zoom ourselves. Thank you all for participating and being here with us, and have a very good evening for what's left of it. Thank you all. Bye.